So today I'm looking to talk about some of the upcoming changes to education law in Wales. As some of you may know, there is a new act that's been passed, the Additional Learning Needs Act, and that was passed in January this year, but it won't come into force until 2020. So I'm talking a bit about what the educational rights of young people, disabled young people in particular, are here in Wales today, obviously how we support them today, and what will be changing when the law eventually comes into force in around late 2020. Okay, so Mel, if you could please go to the third slide. That's just a small disclaimer. Obviously, these are general observations on the law as it stands. They're not legal advice on your specific case. If you want something like that, please do come have a chat with us a bit later.
Yeah, it's all fine.
Next slide, please. So here's how the current law in Wales functions. So you can see we have two systems. So we have the preschool and school educational system. That's generally governed by the Education Act 1996 with a few other acts interspersed, but that's the key act for special educational needs. As you can see, the term uses special educational needs. That covers both learning difficulties and disabilities that essentially affect how a young person can access their education. There are main statutory duties imposed on local authorities and governing bodies of maintained schools. They're direct duties on what you need to do. So, for example, if you have a special educational need that requires special educational provision, essentially that's the support we put in place in the class or in the school on a daily basis to help the person's needs. There is a duty on the local authority to ensure that is arranged. Okay, so if they fail to do that, that's something you can enforce at a court. Okay, so it's a direct duty and it's very powerful. And that's what makes statements such a useful tool for supporting young people and children with disabilities. When we look at these specific duties and entitlements, again, the specific nature means it's enforceable. So, for example, if the statement says you require full-time one-to-one support and they don't get full-time one-to-one support, it's very clear when there's been a breach, and obviously that can be enforceable. So the specific nature of that duty is very, very helpful. It's to an individual directly. And then we talk about statements. Obviously, I've mentioned statements a few times. Those are documents that essentially describe a number of features, but most importantly, perhaps, they describe, obviously, in part two, the special educational needs the individual has. That's needs that have arisen from the special education needs assessment. So that can be things such as autism, it can be things such as dyslexia, but not just those broad terms. It can actually discuss how those needs manifest. So with autism, it could be a sensory processing disorder that requires a quieter environment or a smaller class to ensure the environment is not overwhelming. With dyslexia, it could be processing difficulties that also require a smaller class, but also require specialist teaching that's adapted to ensure there is a reduction of note-taking and just simplified language, perhaps, to help young people access the information they're being taught. So things such as that would be the items that occur both in part two when we discuss needs themselves, but then part three where we talk about, well, okay, now we know what the needs are, how are those needs met? And then in part four, we have the school placement itself, or the placement generally. That can include both school placements and occasionally otherwise than school placements, but it won't extend to colleges under the current law. So, if you are going through that statementing process, either at the assessment stage, at the decision-making stage as to whether or not the child requires a statement, or even when you're looking at the contents of that statement, if you disagree with the local authority's decision in those areas, you do have the right to appeal to the SEN Tribunal for Wales, or as we call it, SENTW, S-E-N-T-W. Now, that's very useful because SENTW, unlike many courts, it does have a lawyer involved as the chair, but actually the two wing members that sit on the panel are educational experts. So they can actually understand the child's needs, obviously arising from the evidence before them, but also from their own experiences. And what you can have then is a discussion. It's not an adversarial process, or it's certainly not meant to be an adversarial process. We have two sides arguing, although sometimes, unfortunately, it can come down to that. Most of the time it's about investigating what the child's needs are, investigating what all the evidence says, and trying to make the right decision. And the SEN Tribunal for Wales essentially resolves those disputes and can make a determination as to what should go in a statement, whether a statement should be provided, or whether an assessment should be provided. Now, if you look at further education, this can apply for 16 plus pupils who are in college education, for example, or those who have gone beyond 19 years of age, and of course that would generally lapse the secondary education. That's currently done under the Learning and Skills Act, and the term changes from special education needs to learning difficulties, although, of course, whether that is a difference in practice is often very unusual. It's normally considered in a similar way. The main duties are imposed on the Welsh ministers, so not on local authorities or schools, not the people directly dealing with the pupils, but more the Welsh ministers. And they're broad duties, so they're more about arranging suitable support within an area rather than to individuals directly. So as you can understand, if you're trying to say, well, have you arranged enough special educational needs support for people in your area? Well, that's quite a difficult thing to judge. And generally, as long as there is enough school places in special schools, you can maybe answer that as a yes, whereas there's an individual child within that system who maybe isn't fitting in quite as neatly as we'd expect. So it's a little difficult to enforce rights in that area because they're not specific to the individual. And there's no requirement for a statement or similar document. What we mean by that, there is a learning and skills plan which does go into planning how a young person should be educated, but it doesn't have the same enforcement rights as a statement. Chiefly among these is there is no right of appeal to the SEN Tribunal for Wales. And as I say, you kind of miss out on that specialism and that specialist decision making because your only right of appeal would really be what's called a judicial review to the High Court. And that isn't quite functioning in the same way because it deals with more how the process behind the decision was made and whether that was done lawfully, which is a much lower bar to hit, rather than what the SEN Tribunal is concerned about, which is looking at everything as a whole and deciding whether the right decision was made. So it's a slightly different viewpoint on things, and judicial review therefore doesn't necessarily have the same satisfying conclusion as the SEN Tribunal. If we can turn to the next slide, please. So the new law in Wales, so I mentioned this at the outset. So the full name of what's generally called the ALN Act, or the Additional Learning Needs Act, is the Additional Learning Needs and Education Tribunal Wales Act 2018. So you can see it's a very catchy name they've given it, rolls right off the tongue. But when was the Act passed? Well, the Act has been, kind of in development for many years now, but it was passed in December 2017 at the Assembly level, and it's now received royal assent in January of this year. So that's when the Queen essentially rubber stamps the document and it passes into law. Now, just because something has passed into law doesn't mean it's in force, and that's important to remember right now. We hear a lot of our clients coming to us, very frustrated with the way their child is being supported, saying, well, the local authority told me they don't do statements. Now, that is absolutely not true. As we saw in the last slide, the current law is in force, the statements are still valid, you can get new statements now, none of that is true, okay? It will only be anticipated right now, late 2020, around September 2020, the indication is, but obviously that could even move further back. It's only once that's actually in force that the system changes from statements to the independent plans that we'll be talking about shortly. So, as you can see, the purpose of the Act is to reform the law of SEN in Wales, and we'll talk about in this talk basically some of the key changes around that, what type of changes you're going to see on the ground essentially, and what that's going to necessarily mean for you. So we can turn to the next slide, please. So again, here we have some of the key changes. Now obviously, with a half an hour talk, this isn't always a comprehensive overview, but these are some of the key things you'll notice. So the term additional learning needs will replace the term special educational needs. In substance, it won't really change the function of the definition, but it's changing the terminology. It seems as though they want to move away from special educational needs to additional. It seems as a means to lower the stigma. I'm not really sure if that's going to have any tangible effect, but that's what the law proposes to do, and that's how the law will carry on forward. It includes provision for preschool, school, and further education and training. Now, it's those latter two that are new. As you saw in the current law, we have, preschool and school, and then we have further education, which is your college-based learning. They're handled by two very different systems currently, and one is certainly more comprehensive than the other. One of the best things the ALN Act does is bring them into one comprehensive system that will more closely mirror the Educational Act role that we have today, with the help of an equivalent SEN tribunal. So that's a good thing. We're also seeing rights of children and young people go up to 25. So currently your rights in the Education Act 1996 lapse at 19, or at the end of the school year you turn 19. What's happening here now is they're looking to extend those educational rights up to 25. And that's quite good because, when you deal with a lot of children and young people with disabilities, my younger sister has severe learning difficulties, trying to get her to learn at the same rate as other pupils who may be done with education at 19. I was off to university at that point, for example. That wasn't going to happen for her because of the nature of her needs. She needed longer in education. So going up to 25 gives those extra 6 years to support young people in education and give them that access to specialist education that they will need to acquire perhaps essential life skills, which is clearly very important for their future development. So Another key change is currently you have a decision after an assessment has taken place whether or not the child requires a statement. Now, it's almost like a self-fulfilling prophecy. It's decided if the child requires a statement, they will get a statement. Well, how do you work that out? Generally, it's interpreted as if the school can meet the needs identified within its delegated budget, that's the money given to it by the local authority to manage the special education needs for all the children in the school, then they generally said they don't require a statement. But if they require further funding or support that's not available through that service, they all generally get it. Now, you can get a lot of dispute about this because one of the beauties of statements is they make everything quite certain. Without a statement, things aren't necessarily enforceable and they may not be drafted in a way that makes them quite clear. So sometimes, you find that having a statement can be better for teachers because you just have one document you read through, says what the needs are, says what you have to do to meet the needs, and then obviously names your school. So it's quite clear, okay, well, I need to give this child and ensure that they have one-to-one each day. Now, that will be put in place by someone above me at the local authority level, but as long as I can see that happening on a daily basis, I can be satisfied that that child is getting the education they need. If I have to adapt my teaching, if that child requires a modified curriculum to suit their needs, I can then identify that child and then say, right, what modifications does that child need? And it's a much clearer and more specific process. Now, a number of disputes arise where local authorities say this child doesn't require a statement, and parents change that view and say, well, no, clearly they do. They're not coping. What you're suggesting they need is not what the experts necessarily say, and we feel that they need more support. They need the protection of a statement. So you can go to tribunal for that reason, and that's sometimes just kind of a wasted appeal in some reason. It's good because if you get it, and often we do, that's very good. You can secure that needs. But actually, it seems to be an unnecessary dispute, doesn't it? You've clearly identified needs. Why can't that just go into an enforceable plan? Well, the new system will just do that. It will get rid of that decision-making of statement yes or no. Basically, every child, whether that child has just a minor level of need that requires only a small amount of support that the school can clearly give, or whether they require a comprehensive specialist package of residential care in England for whatever reason, they will both have an individual development plan, an IDP, and that will work in a similar way to a statement. It will be enforceable. So it really helps with clarity, doesn't it? Because I think it's quite arbitrary these days to say, I'm sorry, you are disabled, but you're not disabled enough to get a statement. I mean, it doesn't seem like a really fair system. Whereas now it will say, no, you have needs, we will give you a plan to help you with those needs. And it's going to be much clearer in that sense. So the duties will be on the school, the further educational institution, and the local authority to secure the provision in an IDP. Now, there's some controversy here because, as it currently stands, the way the law is drafted, the school and the college actually become the first port of call for making sure that IDP is enforced and delivered. Now, that's quite difficult because schools and colleges have not been doing that. That's been solely the job of the local authority so far. The local authority does have a function in this, but generally only if they maintain the IDP. So that's envisioned to be for the most complex children, particularly those who have statements currently. So it's going to be one of the tensions with the new system is to see, well, how do schools and local authorities deal with quite a significant amount of new work that's going to come to them? I mean, generally we know that teachers are wonderful people who work incredibly hard for our children, but they are often overworked. And thinking of adding many more duties to teachers seems like it's only going to lead to perhaps more teacher burnout, more teacher workload, or just increased costs for the school because they may have to hire new staff to take care of some of those functions or relieve staff that will be taking care of those functions. So there is certainly, it remains to be seen how that's going to work in practice, and there is some concern among the profession as to whether the funding has really been, put in place to make this work. But we'll see. The system as it's envisioned is certainly one that in theory looks like it could work very well, but in practice I think we have a number of concerns that we'll discuss a little later. So rights to review of decision-making and IDPs, and ultimately the right to appeal to the Education Tribunal for Wales. So where that will work for schools is that if a school has made a decision to give an IDP to a child and the parent is dissatisfied, they can appeal that to the local authority who will take a look. If the local authority also decides that actually, no, we think the school is right and the parents are dissatisfied, it's only then that they can appeal the local authority to the SEN Tribunal, or its equivalent. It'll be now called the Education Tribunal for Wales. Okay? So, it's only at that stage that we start to see the appeal rights that already exist taking place. And our slight concern is that you're adding a level of bureaucracy, because you've got to challenge a school and then you've got to challenge an authority, whereas now you just need to challenge the authority. You don't need to wait for the school. So there is some difficulty there. Colleges are perhaps put in an even weaker position, because you can challenge colleges directly to the Education Tribunal for Wales as the law is written currently. So it's quite anxiety-provoking, I imagine, for a number of college workers and teachers, that if they get it wrong, and they may not have any clinical training to actually determine a child's needs. I mean, these days we go through an assessment process with educational psychologists, possibly speech and language therapists, possibly occupational therapists. The idea of just having a teacher try and make even an initial assessment and expect them to get it right is obviously a big challenge. So if they get it wrong at the college level, there is a risk that the college itself could be taken to the tribunal, and it remains to be seen how that's going to function, because that's something, again, they've just never had to do before. It's always been local authorities defending or basically facing parents at the SEN Tribunal. Next slide, please. So we're looking at some of the pros and cons. I mean, obviously, there are many more regulations and the guidance is yet to be finalised. So the precise and practical nature of the Act remains to be seen. We have some ideas of how it's going to work, we're being told how it's going to work, but obviously, like with anything, you don't necessarily know how it's going to work until it's enforced. We had a similar situation with the Children and Families Act 2014 in England. Obviously, it came into force a few years ago. It wasn't until we actually saw it working on the ground that we started to understand, well, will all these ambitious aims actually work, or will it simply fall into a pattern of the old system? And actually, it's worked, I think, relatively well, probably better than expected. Yes, there are times when obviously you need to go to tribunal, but what it has done primarily is taken that good work that's under the Education Act 1996 and extended it to 25, and that's probably been overall a net benefit for everyone involved, I think, which is very good. So looking at the pros, obviously the one codified system for young people with ALN up to 25, that's really good. As I said, when you're looking at young people with needs, they're probably going to have a possibly delayed adolescence, but certainly delayed educational history. That gives them the support up to 25. Now, just to be clear, that doesn't mean you have to stay in college until 25. If you can go to university, which isn't covered by the new law, as is not covered by the current law, then you can do, and you can go up to higher education at any point. If you're ready at 18, fantastic. If you're ready at 19, fantastic. There's no need to stay at 25, but if you are an individual that needs it to 25, it will be there for you. So that's obviously very good. Looking at with all children, they get an IDP, as I say, that increases the certainty, is it? There's no, well, yes, you're disabled, yes, you have learning difficulties, but are you disabled enough? It gets rid of that distinction and gives it to all children, which is good. It increases the certainty and the specific duties to those individuals, which, as we said, is much better. It's more enforceable, it's more certain, and we always think that's better for everyone, pupils and staff. And obviously the jurisdiction of the tribunals extended. So as I said, as the current law stands, if you're 16 and in college, or if you're in college education, or you're between 19 and 25, you fall outside of the jurisdiction of the SEN Tribunal for Wales and that specialist jurisdiction that it has. Well, by increasing that specialist jurisdiction, you'll now have that level of decision-making all the way up to 25 as disputes arise, and that can help. Given the specialist qualifications of the educational wing members, they will be able to say, well, I understand these types of needs, and actually I think someone here is wrong, or I think you're right, and it leads to a more open decision-making process. Obviously, High Court judges, although they are incredibly intelligent and experts within their field, they aren't educationalists, and so you can often lose that specialism because judicial reviews are not fact-finding exercises. They're strictly looking at the decision-making process itself and whether there was a fault in that, and that's obviously a much more difficult process to overcome. So it's really welcome to see the tribunal get that jurisdiction extended. So the cons, as I've said, are school and college-based assessments. Obviously we're concerned of, teachers are not clinicians, they're not educational psychologists. Is there going to be a lack of specialism, a lack of expertise in the making of assessments, and could that have a knock-on effect to the quality of plans and the quality of services provided to young people? So it's something that I think really seriously needs to be looked at by the Welsh Government, and they're proposing some form of training exercise, but it's not envisioned for that to last any particular length of time, maybe a few months. And when you think that educational psychologists have to go through a 3-year doctorate, I'm a bit concerned that a few months is never really going to be enough to plug that information gap, as far as I'm concerned. So we'd like to see more robust training services there. In terms of potential conflict with parents, now one of the good things about the current system is because you're taking the case against the local authority, you often have schools supporting parents, saying, look, I deal with this child on a daily basis, and bless their heart, they're trying their best, but it's just not working, and we don't have the expertise. We've tried everything, but unfortunately this poor person has needs that are beyond us. And the local authority may say, oh no, don't worry, we'll add X or we'll add Y, and the school may say, even then, it's just, we're too big. This is a young person with sensory integration difficulties. They're never going to want to come here. It's going to be overwhelming from the moment they arrive to the moment they go home, when they have another meltdown, or they have a meltdown in class because it's just too overwhelming. I can't shrink the school because I'm just a teacher or a head teacher, so you really need to put him elsewhere or her elsewhere where it's going to be smaller and more manageable, and they're actually going to be able to go to school. And you have that dispute with the local authority. So now you have the school and the parents unified. Now, obviously, that's not always the case. Sometimes schools do think they can do a little more, and sometimes there are some disagreements. But what is good is that you're not taking the school directly. You're not challenging the school's decision.
The 11 o'clock seminar will start in 5 minutes.
You're challenging the local authority's decision. So it remains a kind of arm's length kind of dispute at the moment. So it can preserve that right with the school, that even if you've maybe said, oh, I don't think that school is right, and you haven't got that changed, the tribunal said, no, the school can be right, it maybe just needs a bit more support, well then it's quite easy to rebuild that bridge. It's quite easy to rebuild that bridge because you weren't really fighting each other, you were arguing with a local authority about how things should be done, okay? Under the new system, because you are challenging directly the school or the college's decision, there is an increased risk, we feel, that the relationship with the school or the college will break down further because you're challenging their decision directly. So it's no longer saying, look, we agree with you, but the local authority, aren't doing anything to help us. It's now, well, actually, this is my decision and you're wrong, and it can lead to a more fractious relationship. So if, for example, the child is to continue in that school or college after, there is a risk that because of the breakdown in relationship, that will be a less effective relationship, and that's what we're concerned about. By making them defend themselves at the tribunal, the schools defending themselves to the local authority, we are concerned that could break down that relationship with parents and teachers, which is the most vital to a child's education. And the final one is the potential for internal disputes between authorities and educators. Now, this is an interesting one, particularly with schools and local authorities. As I mentioned, schools, when you have under the new system a dispute with the school's decision, you appeal it to the local authority. Now, the local authority has a couple of things that it can do at that point. It can say, well, we'll take over the IDP. We think it needs maybe a little more specialism that we have accessible to us. Or it can say, no, we do think the school is wrong. We're going to change some of the provision, but we're going to make the school deliver it. We have the power to order the school to deliver what we feel is right in this plan. Now, one of the things we do have a lot, and one of the big criticisms of the current system, is administrative delay. That essentially the point of asking for an assessment or identifying a need to the point of getting a statement is a very long, laborious process that can be very, very difficult for parents, families, and particularly the children. And during the period a dispute is ongoing, the concern is that that child is still not getting the extra support they need because we're arguing over the form of it. And it's very important to get it right, so that argument is valid, but at the same time, there is a lot of wasted time sometimes, and we want to shorten that administrative delay. But the new system, because of the potential disputes that can arise between the school and the local authority, there's an extra layer of red tape that can arise. And whilst, that may not arise in practice, it seems likely that it will, because if there's one thing I know from dealing with local authorities on a daily basis is they love to argue between departments and blame the other one for not having the money or not paying this and not paying that. And really, it's one big pot of money, particularly in Wales. Can't we just get it done? Can't we just get the job done? So there's a risk that we feel that with that in place, there could be a dispute between those services, and again, just an increased delay, which is never in anyone's interest. Next slide, please. So there we go. So that's the end of that talk. I'm afraid I only have 5 minutes left, so I don't know if there's going to be any real time to do any questions. But I will be in the booth all day, and I will be at the Q&A panel, so please don't hesitate to come to me. I appreciate that's only a snapshot, so there may be more questions that you have. Again, please feel free to approach me, but I hope that at least gave you some indication of the types of changes we're looking to see when the law eventually changes here in Wales, and reassures you that, yes, contrary to what many, many people think, there are statements here in Wales, so please make sure if a child needs one, they get one. Thank you very much.